All rise. The Eighth Court of Appeals for the State of Texas is now in session.
All right, who's running the Rose? It was giving me a box that said that you wanted me to unmute. Okay. But I was not heard over the courtroom.
Mr. Shihara maybe didn't hear you.
Okay. Okay, when you whisper, I can't hear you. All right, so Mr. Shihara, I apologize if you were not able to hear me. Go and have a seat. I was discussing your request to appear via Zoom, and there is no objection, so we're going to go ahead and allow you to do that this morning, really in the interest of making sure that we can move forward this morning. So, Mr. Cunningham, do you want to begin?
Thank you, Police Court. My name is Jonathan Cunningham with Fidelity National Law Group and represent. And represent the appellants, WBL, SPO 1 and SPO 2.
that was the initials the Chief Justice referred to as appellants in this case. I would like to briefly just take a half a second to say what a pleasure and honor it is to finally make oral arguments before the El Paso Court of Appeals. I have been able to for 30 years since I was a briefing attorney for Justice Paul McCollum here at the court. So finally I get to make the arguments. That being said, where to begin? There's a few of a litany of issues in a way that have been briefed, and of course we rely upon those briefings. Of course, willing to go wherever the court wants to go, but I guess in some way, a little bit one of the better ways to start is almost kind of like a back going forward in a sense, and at least to start with the issue of SPO's, the trial courts erroneously striking SPO 2's intervention. Very quickly, at least on that issue, at the time that SPO 1 made its intervention, it indeed, and it's uncontroverted, that it was the assignee of the Axis Bank deed of trust and note. And so therefore it held an interest in the property, should be a proper party, and it was affected by the claims that were being made, and therefore a proper intervener. While that was pending, and the plaintiff had brought its motion for summary judgment prior to that intervention. So when they intervened, there was already a motion for summary judgment that was pending against Mr. Chiata, the other defendant. And so as that went on, it finally came to light and became known that in 2023 or 2021, the parent company, WBL itself, had indeed, for its corporate purposes or whatnot, transferred the interest in the property to SPO 2. And in doing so, what they had done, and it was in the property records, it's uncontroverted, recorded, that they had taken it back from SPO 1 into itself and then put it into SPO 2. So when that became known, counsel, shortly before, during that, and around that time that it became known to counsel, plaintiff had filed a summary judgment against SPO, okay, 1. So SPO 2 did file an amended original intervention to replace itself as the party in interest, the one who had actually held the interest, the proper party. Can be characterized as stepping into the shoes. It's been characterized as not having made an original, but it did. That's the amended to replace itself as the appropriate intervener, and moved on. Did go ahead and respond to the summary judgment motion that had been brought by plaintiff, and such. In the plaintiff's response to the summary judgment, that's where they raised this motion to strike the intervention by asserting erroneously that WBL, the parent company, could not or did not have the authority to make the assignment to number 2, SPO 2, because what was missing in all of that was the transaction from SPO 1 back to WBL and then to SPO 2. The information to the court regarding that exact recorded transaction was indeed made known to the court. It's at court's records. It's on page 736, but it's in SPO 2's response to this motion that had been brought up, where they did indeed alert the court of the recording of the and by document number of the actual transaction from SPO 1 back up to the WBL and then over to SPO 2. Told what document number it was in the property records and such. So they alerted the court. That information was known to the court. There's a whole issue, and it's briefed, and we'll stand on it as to whether or not the plaintiff even has standing such to complain about such assignments. And I'll stand on the briefing that they don't without going into it. But the actual uncontroverted fact is that although the court erroneously did go ahead and strike the intervention, in a very appropriate motion for reconsideration. SBO2 did present, and it's a court's record, and its motion to reconsider, which is a court's record 745, did present at page 806 in the court's record as Exhibit F, a true and correct copy of the actual document recorded that showed the transaction back from SBO1 to WBL, and then of course the next exhibit appropriately back from WBL to SBO2, alerting the court and for all purposes of preserving the error, to allow him to change his mistake and of striking, that the uncontroverted facts in the property records are that indeed the assignment was correct, and SBO2 was the proper intervener. It's been asserted by the plaintiffs that somehow that's a business record that was made known that we had it. Well, it was in the property records long beforehand at the time it was done. So we alerted the court to it. We told the court, we asked the court to take judicial notice of it, made the error. We then actually presented the actual evidence copy to the court.
So can I ask you just a follow-up question to
Yes,
that
sure.
then? Since our standard of review in one sense would be a de novo review of the summary judgment record here, how would you define the scope of our record?
Can you unmute yourself?
And
Let me repeat that. Sorry, I gotta repeat it.
go right ahead, Judge.
All
right. So you were talking about this transaction occurring and the motion for reconsideration. So I just take a step back from high level. What do you consider to be our record? Does it include everything that was filed from the beginning motions all the way through the motions to reconsider?
Yes, Your Honor, I do believe, and I'll quickly try to explain that. I do understand, if I understand your question correctly, in the court's review of the summary judgment proceedings, you're limited to the summary judgment part of the record. Well, in particular, since this motion to strike was actually raised as part of the summary judgment proceedings in the plaintiff's response, I do believe that then encompasses as well what was the record that was put before the court regarding that motion. That's the reason why SBO2 did do a response back and as part of its reply, and presented the court the evidence as well as the case law that they don't have standing regarding that aspect anyway. And then he made the ruling, and therefore, even as a matter of, as he made an erroneous ruling on that motion to strike itself, since that is an appellate point, I believe that all of that does get encompassed into the record for review as to whether or not the court just simply didn't pay attention to the law and the evidence, and it is indeed there that SBO2 is a proper party.
Can I ask you a question? If you're saying, I know that you wanted to, that you start backwards because that makes sense to you. I started from the beginning, and so if evidence is readily controverted, but we don't get that even by your argument until this motion for reconsideration that you consider was the evidence that was in your favor. How does the trial court make an error if you don't raise it until that motion for reconsideration? And then tell me how it's competent summary judgment evidence.
And this is where I'll break that up, Your Honor.
Okay.
I believe because it does appear to start getting convoluted that way. But in relation to the summary judgment itself, start from the beginning. And this incorporates actually Mr. Chiata's aspect. You start from the original summary judgment that was obtained against Mr. Chiata. Okay. And as a matter of law, because that summary judgment was the sole ground brought as for summary judgment, traditional summary judgment against SBO, the intervener, okay? That first entails the issue of, was that summary judgment, two issues actually. Can you use that summary judgment, which was by essentially default because he didn't make a response, can you use that interlocutory summary judgment against an answering defendant? And the case law and the precedent is no, you cannot. So itself being a ground wasn't appropriate and competent summary judgment evidence for a judgment against the SBO. Beyond that, as well, the second part of that summary judgment, the Shiata summary judgment, was that even on appeal for the first time, if it was solely based on, did they meet their burden to be able to, because it was solely traditional, did they meet their burden to even raise the requirement for a response, even by Mr. Shiata at that time? And that's been briefed here, and the answer is no, it did not, because the keystone conclusion was merely conclusory, that it wasn't by an affidavit, that the transaction had not been approved by the requisite number of members. That was merely conclusive, no underlying facts. That's been briefed by both us and Mr. Shiata. That didn't work. In the responsive briefing, where they tried to say, well, he did do, it's not conclusory here. They left out any analysis of that one cornerstone aspect of that conclusion, that it wasn't right. The approvals. It was conclusive. So going forward, just Mendoza, as you want to, you first have to say, was that summary judgment even itself valid? Then can you use that summary judgment as the sole ground against SBO? No, you cannot. Now, they did say no evidence motion. They raised a no evidence motion against SBO as well. That's where SBO 2, and this I believe Justice Mendoza is where the evidence actually was raised. We did SBO 2 in response to the summary judgment motion, did indeed, as to the no evidence portion, produce evidence of the approvals, of the necessary approvals that in its response. So that was in its response to the summary judgment. So that summary judgment evidence was there. Okay. And then in relation to the traditional part of the summary judgment that was brought, utilizing that the summary judgment ground is only this other order, this interlocutory order, that's not competent summary judgment evidence. That's where, so in answer to your question, Justice Mendoza, contravening or competent summary judgment evidence to defeat their motion for summary judgment was actually raised in response in the summary judgment evidence of the approvals. It was not contradicted. It wasn't objected to. And so it was there. That's sufficient to raise the issue, both as to the no evidence, as well as even beyond the fact as to traditional motion, it would defeat a traditional motion, that it raised more than a scintilla of evidence to the plaintiff's claim that indeed there was indeed the approvals, the requisite authority. That ends up dovetailing quickly into the issue of the void versus voidable misunderstanding that has gone on with plaintiffs in this case. They've continued to try to characterize both the Glassner judgment, which is from another case, as well as the interlocutory Shiata MSJ order in this case, as having twice the court has ruled that this transaction was void ab initio. That is not a fact. The claims here were that it was fraudulent transference because it had not done with appropriate authority, or in the Glassner case itself, the other case where she was bringing it was on an unsecured loan, and so she brought it on the debt and brought a Tufta claim in that case to try to make that judgment executable for her for any judgment that she obtained, and that's the judgment that she got. So what that judgment did is between those two parties, because SBO and its lien interest was not an issue in that case, was not a party in that case, that judgment gave her judgment and ruled that that transaction was void as to them, and thereby making the property subject to execution of her judgment once abstracted and a lien attached. It is uncontroverted, by the way, that her abstract of judgment and therefore her judgment lien attaching was after Axis Bank's lien. Okay, so even as a judgment lien, it comes in junior to any previously recorded lien. That's her effort in this case, is to try to knock the Axis Bank SBO's lien interest out of its senior position by trying to claim that, oh, it was void ab initio. That's not the fact. All the pleadings, even in this case, are all that whatever fraud it was made it voidable. And that is, and the case law is absolutely clear that it's that one that's merely voidable operates totally effectively to achieve its purposes in the meantime, in the interim, until in a judicial proceeding, it is voided. It is thereby voided. Both of the languages in both of these orders, by the way, the Glassner order and the interlocutory order, use the present tense is. They don't say ab initio. It says hereby void, is void. That is totally in compliance with voidable precedent, voidable case law. It didn't try to say that it was ab initio. It would have been error to do so. And we point out in the case law, or in the briefing and everything, and it's important that the Supreme Court on down for a long time has made this distinction between void and voidable deeds, because it takes a suit to set a voidable one aside. This distinction, the courts have said, and we brief it, and I'll quote from the Lighthouse Church case that we brief. They say the primary distinction that we find between void and voidable deeds in Texas law is in respect to the rights of an innocent purchaser. A voidable deed operates as valid and perfect until it is set aside by judicial adjudication. And that has been recognized by this court, actually, long back to 1958, where actually the Supreme Court in the Nobles case cited this court's 1958 decision for that exact same proposition, where the Supreme Court, in relying upon the El Paso court, said the deeds procured by fraud are voidable only. They're not void at the election of the grantor. And it is settled that such a deed is valid and represents a prima facie evidence of title until there has been a successful suit to set it aside. That is actually, again, been recognized by this court as recently as 2018 in the Heredia case, Heredia case, where the court recognized, once again, relying on nobles that relied on this court, the deeds obtained by fraud are voidable rather than void and remain effective until set aside, such that everything in between happens. There's an innocent purchaser that gets a lien interest or such, or even an innocent purchaser in between in that interim. It's effective. It's effective. As a matter of fact, that was even recognized by Judge Halifax in the Heredia case, that during that interim, a purchase for value is accepted. And so it becomes, in this case, the way that works is, even if, as to Ms. Glassner's judgment, even if it were to go, it was found to be voidable and go back to the fee interest, go back to United Hotels, it goes back to United Hotels with the lien interest of the Axis Bank, the SBO lien interest, because that was innocent purchaser that happened in between. But that actually, in the last few seconds, I want to say, still doesn't get there. That's still to be determined, because the summary judgment fails because the requisite competent summary judgment evidence on the validity of the approvals by the members for the transaction, for the transfer between United Hotels to the Dream, still survives as a fact issue, at a minimum, to overcome summary judgment. So that the court's, this court's determination of voidability still is in error and subject to being defeated the Chiata summary judgment aspect, subject to being actually proven wrong, being defeated by the other answering defendant or the intervener, SBO. I understand that I've got 30 more seconds. I hate to say I'll let Mr. Chiata speak up or such, if he cares to, or any questions that still arise by the court. But I believe the rest of it is, the entire record is there. It becomes clear that that this judgment needs to be reversed and remanded back to the court for the appropriate proceedings.
Thank you, sir. And I should have mentioned at the outset, this is like my second oral argument to make sure that you all know that we have reviewed it, all the briefs and the record. So know that that has been done. Mr. Shihata, Mr. Cunningham indicated that he was really covering your side of the argument and did use the full amount of time. But if there's anything you want to add briefly, I'm going to give you an opportunity to do that now. Neil, are you okay? You're muted, sir, so you need to unmute. Sir, you need to unmute. It didn't unmute him. Did you do that, Nadia? Can you unmute him? I can't.
Are you hear me now?
Mr. Shihata, we didn't hear you earlier because you were muted. So as I said, I was giving you an opportunity to say briefly anything that you wanted to add.
Yes. Are you hear me now? Yeah.
It's a little soft.
Okay. I just a little point regarding the capacity, like for Mr. Georgie and Mr. Attorney represented from Mr. Georgie United, because I am the only sole manager for the United Hotels, and the Mr. Georgie is not a member or unauthorized to make any action. That is conflict with the clear of the operating agreement for the United Hotels. And I appear in person in the trial court, and I told that I am the only one to represent it United. How now other one not a member, not unauthorized to file this case? The second thing, the last thing, I have already provided and represented the consent of the 13 of member. That is already consent for the transfer, because the transfer is very necessary. Why? Dream is a sister company with the United, with the same members, same everything. The reason we make it a transfer without any money, because we have entered in the franchise agreement with the Hilton Worldwide. We paid 100,000 initial fees, and we have a liquidation for 1 million if terminated. When I reapplied for the franchise, Hilton, they needed another name. They cannot accept the United again. For that, I just transferred to Dream, the sister company, to avoid losses over 1 million. That is all.
Thank you, sir.
Thank you so much for hearing. Thank you.
Can you mute him again, please, Rose?
May it please the court. My esteemed colleague has deferred. We originally agreed to split the time 50-50. She's agreed to defer to allow me, because she knows how verbose I can be. So
it went quickly, so
she said, yeah, go ahead and I'll take what's left. Very kind. And may it please the court. There are a number of let's say, inaccuracies in how this case has been portrayed. First, and as I believe you pointed out, Justice Mendoza, is when the issue about striking WBL SBO 2 LLC's response to the second summary judgment filed in the trial court. When that motion to strike was filed, the burden, according to the Texas Supreme Court, the burden then shifts to the intervening party to prove that they have a justiciable controversy that is appropriate under Texas Rules of Civil Procedure 60, which deals with intervention. Here, they filed a couple of deeds. The first deed showed that their parent company, World Business Lenders LLC, had sold and assigned the property in question to WBL SBO 1 LLC. It's ostensibly not its sister company, but it's related somehow company. At any rate, they submitted that as part of their evidence as to why they should be WBL SBO 2, why they should be allowed to intervene, why they should be involved in the case at all. And they also submitted, and this is part of the record, a second deed that shows the transfer from World Business Lenders, approximately 7 months later, from World Business Lenders to WBL SBO 2. And they use that as justification, saying, hey, we have the right to be here because the property, the deed has been assigned to us. And opposing counsel says, well, if you weren't a party to that deed, you don't have standing to challenge it. Well, what we did was we raised the issue with the court because they had the burden to show that those transfers actually took place. They provided the deeds, but based on their own evidence. World Business Lenders transferred that property, sold and assigned the deed to that property to WBL SBO 2 once after it had already assigned it away. In other words, the evidence that they submitted showed they had transferred the property to their first subsidiary and then 6 months later or 7 months later transferred it to their second subsidiary, which is what we argued when we got in front of the court. We didn't challenge the validity of the transfers per se. What we did was say, hey, Judge, you know, this whole burden of proof thing lies on them. The evidence they presented showed that they didn't transfer the property because the property wasn't owned by the party that purported to transfer it. Based on that, the trial court decided, well, you're right. You haven't presented evidence of a justiciable controversy, and therefore I'm going to grant the motion to strike. Now, opposing counsel briefed for pages about how that wasn't right and how that shouldn't have happened and how that, and okay, you do what you can. But that being said, the information that was before the trial court at the time he was asked to make the decision was, and this was evidence presented by them, was that they didn't have a justiciable controversy. In other words, they didn't have the grounds to intervene. Now, the determination of whether or not that determination was appropriate is abuse of discretion standard. And based on what the judge had in front of him, not only was his decision correct, there is nothing that could reasonably argue with a straight face that he abused his discretion in making the decision to strike the pleadings of SBL. In other words, take them back, they're not an intervener, sorry. To make that decision and strike their pleadings. Well, as a result of striking their pleadings, there was no answer to the motion for summary judgment. Now, this is the second motion for summary judgment. The first motion for summary judgment, the court granted, invalidating the transfer of the asset, the real estate. Now, opposing counsel stood up here and talked a lot about liens and the rights of liens and how you have to respect the lien and all the stuff about the lien. But what he ignored and what we put in our briefing was, yeah, but you can't have a valid and subsisting lien on a piece of property that you loaned money on and then slapped your lien on once that transfer has been invalidated by a court. Now, he also said, well, it's good until it's determined by a court. It was. That was the whole point of the underlying case. We challenged, even before I filed the case, Guy Glasner filed a separate lawsuit because the Dream for Investments kind of went up in smoke and didn't pay its bills. So she sued him. And when she found out what had happened, in other words, Mr. Shihada had taken the only asset of the company and transferred it to his LLC that was now being run by his daughter, they sued. And they sued to invalidate the transfer of the property, and they won. That claim had been adjudicated completely and fully before we ever got to our motions for summary judgment. I didn't know about it. I wouldn't have filed. I found out about it when the judge in Andrews County District Court said, man, these guys sure are getting sued a lot. And my eyebrows shot up.
I'm sorry, can we come back to this lawsuit and
Sure.
I have a question about that. Looking at Dawson Georgie's affidavit.
Yes, ma'am.
And specifically paragraph 6.
Okay.
And more specifically, the first sentence. The members of United Hotels were not aware of the sale of the property until the sale was discovered months later, nor had the members authorized the sale of the property. What members is he talking about?
There's a group of members that are all located in California that were solicited or approached by Mr. Shihada to invest in this deal.
So you're going to tell me about the, I guess it's 5 members that comprise the original group of United?
Yes.
Okay, so aside from you telling me, I want to look at the contents of the affidavit. How are we to understand who these members are, whether they're the 5 plus Mr. Georgie himself, or whether they're the 17? How do we know who these members are? It just says the members of United Hotels. How do we know from this affidavit?
From that affidavit, you cannot tell. And I hate to give ground here, but to that point, opposing counsel has said, well, it's conclusory, throw it out. The problem with that is that it is the entire, that statement is not conclusory simply because it doesn't name the individuals, provide their address, social security numbers, whatever the level of specificity that would have satisfied opposing counsel.
Well, let me ask you this, what was the A1 exhibit? I don't have it in front of me, but was it that transfer to Dream?
Yes, Judge, I believe it
And
was.
was that the transfer that's signed by 12 purported members, as far as we can tell?
No, Judge.
Okay, describe to me that exhibit in one.
Exhibit A1 was the only signatures on that notarized weren't the shareholders except for the managing member, Adele Shihada.
Okay, so tell me in this affidavit, because we have to stay in our lane.
Right.
On appeal. And so I'm trying to understand the foundational facts for that statement that doesn't identify which members, while at the same time attaching a document where 12 purported members, as far as I can tell, have signed. And so I'm trying to understand what this means. Does this mean that Mr. Georgie spoke with 5 other members, or minus Mr. Shihada, and ascertained that they didn't know and then are reporting back to us in this affidavit? Is he talking about members being now all of these members that might be in United? Is he looking at documents and possible physical notices that aren't present? What's the foundation for that statement?
There is none contained within that affidavit except for the statement that, excuse me, that the members with which Mr. Gregory was associated had not only voted on it, but did not know about it. Now, I will bring to the court's attention that the document I believe you're referring to wasn't the exhibit that was attached to our motion for summary judgment. That one did not have the signatures of any other member except for the manager, Adele Shihada. Later, and not in any kind of response or reply to that motion for summary judgment, but later, Mr. Shihada comes up with this document that purports to have other signatures on it. We had never seen that, and it had not been on file with the county clerk's office. We don't know where it came from, the date it was created, or anything.
Was that included in a motion for consideration on Mr. Shahada's part?
I'm stretching my memory to try to remember exactly when he filed it. Mr. Shahada has a habit of filing things kind of randomly. In other words, not necessarily when there's a motion pending or not
Well,
necessarily.
my question is simple. It's just whether it was or was not filed in a motion to consideration. I need to know if that's part of our record.
Is it a motion? No, I do not believe it was filed in connection with the motion for reconsideration. Now, Judge, as to this whole attack on the first motion for summary judgment, I will point out that the party that was affected, now, the finding of liability for breaches of fiduciary duty, that was against the individual, Mr. Shihada, who has been referenced quite a bit here. Also, the Texas Theft Liability Act, because he took property from a company that he was a manager for and put it into a company that none of the shareholders that hired me even knew about until immediately before they hired me. But the thing is that the dream for investments never actually appeared in the underlying lawsuit. As your honors know all too well, you've got to be a lawyer if you're going to show up and represent a company or an incorporated entity. Mr. Shihada is not counsel, that's undisputed. He is not an attorney licensed here or anywhere else. And so he filed an answer on behalf of himself, his daughter, and the company. But since then, nothing has been filed on behalf of the Dream for Investments, not even this appeal. In this appeal, Mr. Shihada filed on his own behalf. Well, if he's appealing the judgment against him for breach of fiduciary duty or the other claims against him, that's one thing. But the Dream for Investments is not here before the court. No motion, no pleading, no briefing, no appeal is before the court on behalf of the company against whom we obtained a judgment saying, yeah, that whole sale for no money, that's void. And it was voided. As we kept hearing this a little bit earlier too. Void versus voidable. To be, may be voidable, but to be void, it has to be determined by a court of competent jurisdiction. It was. That's what they're appealing, was the finding that the transfer was void. So we just checked that box pretty cleanly. The issue about whether or not, the trial court erred in granting the traditional and no evidence motion for summary judgment against WBO SPO. Well, it would have been one at the time because we struck the pleadings of the intervener, WBL SPO2, which was the only party that filed a response of any kind to the second motion for summary judgment. Therefore, what was in front of the court at the time was basically an absence of any party showing up and saying, Judge, this didn't happen. Any party that had any standing. WBL SPO2 tried to do it, but they had shot themselves in the foot when they presented evidence in response to the motion to strike that demonstrated that they weren't the owner. And opposing counsel got up here just a little bit ago and said, well, there was evidence. There was a deed that was filed transferring property from WBL SPO1 back to its parent company, who then later transferred it down to WBL SPO2. I haven't seen that. I saw a reference to it in their pleadings, but I haven't seen that document. And the judge who was put into place to rule on this certainly didn't see it before he made his ruling. So as far as the motion to strike, it was absolutely appropriate. There was no abuse of discretion, and there's nothing even close to the evidentiary standard they would have to reach to be able to demonstrate to this court that the motion to strike was inappropriate. Now, the affidavit is problematic. Justice Soto, I agree. I wish I could go back in time and draft a better affidavit. But at the end of the day, it is enough on its face to justify, in the absence of objection or response or any action at all by the party who was directly impacted by it. Remember, at this point in time, we didn't know about these guys, or we just barely learned about them. At the time that we filed the motion for summary judgment, we hadn't heard of Axis Bank having a link. We found out about it. We amended our pleadings. We included them in RIM, not even knowing that they had already sold it to his client.
And what's your best legal theory for this being enough?
I would argue that it's not conclusory for a shareholder to say, hey, neither I nor the other shareholders knew that this had happened. We just discovered it.
But these are, he's using the word members.
Yes.
Okay. So, but no, I understand what you're telling me. I just want to know your best legal authority to support that.
I'd have to file a post-oral argument brief to provide that because off the top of my head, I don't have it.
Okay, well, yes, it's okay. I'm not requesting one.
Okay. And I've got just a little bit of time left. I'm going to give that to my very, very tolerant and lenient co-counsel unless the justices have any questions.
I do have any questions. Go ahead. Just jumping at the Texas Theft Liability Act on the intent element.
Yes.
I do see paragraph 8 in that same affidavit speaking to that element of intent. What else, if anything, in the record conclusively establishes this?
The intent to deprive
Correct.
United Hotels of their property.
Yes.
What we used as kind of exhibit number one is the fact that Adel Shihada signed the deed, that deeded it over to a company that none of the shareholders had heard of until this lawsuit got filed.
But as the managing member.
Yes, as the managing member, which was prohibited under the operating agreement from transferring all the assets of the company without the membership getting together and voting on it.
Right, and then he proffers signatures by a supermajority. I don't know any different. 13, what is it, 13 of 17?
Something like that. Yes, yes.
So I again go back to, other than paragraph 8 of that Bass and Georgie affidavit, what is the evidence, if any, of an actual intent to deprive?
Just what I described, the fact that he transferred the property. We have a signature on the documents that were filed with the county land records that did not have signatures of other shareholders affixed.
Understood. Thank you.
Thank you, Judge.
Good morning.
I'm just going to jump in and answer a little bit more on that front. And with regard to the intent, the background here is that the members of United Hotels had invested in this piece of property to build a hotel. There was another piece of property, and it's referenced in the briefing, A&E Hotels, that was a sister entity as well, some similar membership to some degree. But what you have to understand here is there's a lot of litigation because you had commingling of assets, other things that are alluded to, but not in the form of evidence in this particular proceeding. With regard to the shareholders themselves, the original operating agreement, which is appended as MSJ evidence throughout the record, only identifies 6 shareholders total, including Mr. Shahada, so 5 and Mr. Shahada.
Can you just point us to the record where those 5 members, including, and plus Mr. Shahada are actually referenced?
I don't have the record right in front of me, but, give me one moment, I might have a quick reference.
Okay.
If we get lucky and if I have a cheat sheet.
So anyway, while I'm looking for that, the other document that is in the record, which I believe was originally attached
To a document that Mr. Shahada filed after the MSJ against WBL SPO 1. But he styled it a motion to dismiss. Anyway, attached to that was this agreement that he keeps saying he had the consent for this transaction. If you look at the signature pages on that agreement, and I'll see if I can pull a record site for you for that as well. Okay. But if you look at that document, it lists persons who are not on the operating agreement.
Right, so that's my question. So where is the proof that those additional 12 members were improperly added such that they could not possibly constitute the supermajority of the 17?
There's no documentation whatsoever. The original members never signed anything, so they don't have any proof that they could give you to say, here it is. The only person that could manufacture that proof is Mr. Shahada. But the original members never consented.
So is there an affidavit telling us that these purported 12 extra members were added inappropriately in violation of the operating agreement such that they could not possibly constitute the supermajority?
There's not, and that's the fun part of this whole entire case is that agreement was provided to the court, to the trial court, after both MSJs.
But I guess I'm looking at the United's initial burden on summary judgment, and again, we're trying to stay in our lane here.
I understand. And unfortunately, it's one of those things where there was no way at the time that the affidavit was being drafted for anybody to know that Mr. Shahada was going to produce this document showing 13 unidentified individuals unknown to anybody else that had supposedly become members of a company that Mr. Ivy's clients had no idea had become members of the company. You know, it's one of the things where it's a gotcha after.
And was there any response to his filing?
A response to his filing. So he filed the MTD. Then I believe after that, there were the 2 motions to reconsider because Mr. Shahada did join in the motion to reconsider with WBL SPO 2. And he was attempting to ask the court to reconsider the merits of both MSJs. And there was a response filed there, but I do not believe there was an additional affidavit attached to that. But that's all motion to reconsider. That's
Understood.
Yeah.
I'm just trying to look at our record before.
Yeah,
It's a very odd case.
It is a very odd case. That is very well put, Justice Soto. And if it's in the opinion at the end of the day, I can understand why. But anyway, excuse me. Let me see if I can find you that reference to the operating agreement. Have the record side. And then I do believe, there we go. February 16th, 2017 is when it was signed. CR 462 through 464 is the operating agreement. The members who signed. Adel Shahada. I'm going to massacre these
No,
names.
it's okay. You're telling me it's a 6.
Yes, 1, 2, 3, 4, 5, 6. One of the members is L. Barreri LLC, and that is Mr. Gregory or Georgie. I tend to do that with his name. But yes, CR 462 through 464. And that number tells me that was a part of an MSJ filing. Is there anything else that I can answer for the court?
I guess I would ask if you could also tell us what is your response on the affidavit being conclusory or not conclusory?
So my response is a little bit complex and I apologize. So let me try to briefly respond. There are statements within that affidavit that are absolutely not conclusory in any way, shape, or form. With regard to the paragraph 6 that Justice Soto was referring to earlier, when, as the case law clearly states, both experts and lay witnesses can provide conclusion testimony based on their observations, etc. There's a very difficult line to draw, and I think the case law even states that it is a very difficult line to draw between conclusions that are about legal results, which are clearly not permissible. You can't draw conclusions that say, if Mr. Georgie had said, Mr. Shahada breached his fiduciary duty, period, end of sentence, sign my name. That would be a conclusory affidavit that is not rising to the level of evidence. But in this case, he went through and explained what had happened. 2020 hindsight, it would have been great for him to list and identify the members known to him, but the members were the 6 that had signed the operating agreement. And so that's what he knew. So it's always fun in hindsight as attorneys, and I know the justices all have been through this, to look at a document you prepared and thought, well, I could have done that differently. But that doesn't mean that the document doesn't contain evidence in support of the MSJ. It doesn't mean that it's insufficient. I believe that there is plenty of evidence within the affidavit to support the MSJ against Mr. Shahada and the Dream for Investments. I would also point out that at the time, I take that back, I'm thinking about the record. The affidavit of Ahmed, there was an additional affidavit that was input into the MSJ record later through the filings of my client, Ms. Leisner, that had additional information, but I don't believe that was on file at the time of what I refer to as the TDFI MSJ in this case. So that was later with the WBL SPO1 MSJ.
Great, thank you.
Thank you.
Again, please, Clark. Trying to answer a few of the record questions you might have, Justice Soto. You referred to Exhibit A1 of Mr. Georgie's affidavit. My recollection, I believe I'm correct. Exhibit A1 was a copy of the operating agreement. Okay. Yeah. So when he was referring to, in other words, there was nothing attached to the affidavit that gave any factual basis for the statements that you brought up from that paragraph about their knowledge, somebody's knowledge. I mean, the legal precedent is you can't testify as to somebody else's knowledge.
So you're saying Exhibit 1 was the original operating agreement?
That was
Exhibit 1?
Exhibit A1 to
A1
Mr. Georgie's affidavit
was the original operating agreement.
was the operating agreement.
Doesn't that suggest then that the members were those original members? That's what he's talking about?
Well, my suggestion is the way he was trying to support his statement with that exhibit was he said that it wasn't made with the knowledge and was not approved by the members as required. This is the rest of that paragraph, as required by the operating agreement. He said, yeah, and he refers to Exhibit A1, the operating agreement, the paragraph of requiring a supermajority of the members. So going back to the legal requirements of conclusiveness, is that he has to have in there, contrary to opposing counsel's statement, it's conclusory even on facts, not just law. It's not competent summary judgment evidence. If you make a conclusory statement as to facts and you don't relate the basis of that conclusion, the factual basis of that conclusion. I believe Justice Soto, you brought up a very good point. He doesn't say who those members are that he's referring to, whether it's the original members, the new members, or additional members that were brought up, whose approval he was supposedly talking about. He can't, it makes no relation as to who did approve, who didn't approve, and therefore there wasn't a supermajority. Those are the facts that have to.
Under some of the case law does suggest though, that if the information is readily controvertible, then certainly, meaning here, I would assume if there was consent, he could controvert it easily.
Well, and once again, though, I do go to the burden, the initial burden, and this is brought out by the Supreme Court, and I even refer to the Townsend case from the San Antonio Court of Appeals. The initial burden, in order to even make that response, even
To shift the
have to
burden.
have.
So you're saying it never shifted the burden?
It never shifted the burden. If you proffer a conclusory affidavit, which is not competent summary judgment evidence, okay, then it doesn't shift the burden, okay? So
Well, wouldn't it seem like that would be a reasonable person type standard? Because certainly you would think anybody would reasonably, if they had consent, they would reasonably put forth that consent.
and other than the fact, Your Honor, I don't believe that that's in the law. I mean, I believe the law is specific. I mean, that's no more than the allegation that was made in the pleading, that it wasn't made with consent. That's all he's really saying, is the same thing as the allegation that was pleaded. He doesn't offer any competent summary judgment proof that there was not the supermajority of approvals that was required. He simply makes a statement, wasn't approved by the members. You have to provide the proof that there was not a supermajority in order to have the other party needing to respond to bring up more than a scintilla of evidence that indeed there was approvals.
Okay, so second question then, are you arguing that the original members didn't need to consent to the addition of new members?
And let me preface my response, Your Honor, by the way, with this. And we brought this up in our reply. If we're going to start arguing about the merits of whether or not new members were appropriately brought on and whether their approvals counted according to the operating agreement and such, then more than a scintilla has already been raised. We're down into the fact issues to be tried by the court as to whether or not these new members were brought on appropriately and such. None of that evidence was part of this motion for summary judgment, the first one or the second one. None of what was required to bring on new members was part of any summary judgment evidence. This is all raised for the first time on appeal, okay? I want to preface it with that. We're already into issues of fact. But the reality is the operating agreement does indeed state what the requirements are, or what his authorities were or are, and I would go to the reference in the clerk's record at page 303 of the clerk's record 303, section 5.1.3.8 gave the managing member the power to amend the agreement, or let me put it this way. It says that it has to have the approvals except for it. It's just out from needing approvals. The managing member may consent to amend Exhibit 2 and Exhibit 3. Exhibit 3 to the operating agreement is the membership, is amending who are members and such. In the event that new members are admitted, that is an exception out of requiring approvals.
But let me ask you this, but regardless of whether technically under 5.1.3, limiting the control of the managing member, regardless of whether he had the ability to bring on more members or not, we don't have evidence of whether members were brought on or not, or which members were members at the time, the relevant time in the summary judgment motion.
You do actually, Your Honor. And I'll give you the court's record reference once again, page 416. Page 416, these are exhibits that Mr. Shihada filed part of his reconsideration. The stuff that was an answer to your question is part of the reconsiderations and such of the articles, page 416 through page 425 is where they admitted the new members, specifically page 420 was the amendment to the operating agreement, that here are these new members that were admitted pursuant to the sections of the operating agreement, and gave the listing I know I can show you, but I'm just saying it's
We have it.
the entire listing of all of those. You then, the point being is that all that is supporting evidence for what was given as competent summary judgment evidence by even SBO, okay, in its response, okay? One of them is done twice in the record. Once it's at course record 348, which was the agreement regarding the transfer where all the signatures of the new members that created the supermajority were given. And that was attached to Mr. Chiada's affidavit, such in his reconsideration, which came before the time to respond by SBO. SBO2 did include that in its summary judgment evidence, his affidavit, all of that he had, all of that, as summary judgment evidence in its response. So that's where the more than a scintilla was raised in response to the no evidence part of the summary judgment of SBO. I want to briefly just say that this whole aspect of, oh, well, it's SBO that did it, therefore SBO 1 didn't actually have a response. The whole point was at the time of that response, the time of the response, it was SBO 2 filed its amended intervention to replace itself, step into the shoes, inure to the benefit of SBO 1. So when it filed its response in the summary judgment and all of that evidence, that endured to the benefit of SBO 1 because SBO 2 was stepping into the shoes and saying, I'm here under my allegation that I'm actually the party. And they want to say, oh, well, then therefore there was no response by SBO 1. Yes, there was, because it was there under the pretense, under the purview of SBO 2's response. I remind that the sole basis of the no evidence motion, I mean, of the SBO summary judgment, the traditional part, was the court's interlocutory order regarding the Chiada judgment. That was the sole evidence. Two pieces of evidence were attached, the Glassner order and the interlocutory order. So all of this about where new members were and all this stuff, that's where I'm going, Judge Soto. All of that goes to the merits that would be tried. So in answer to Justice's questions, Chiada did produce all that evidence in response to reconsideration for his MSJ. That all of that evidence was actually unobjected to, uncontroverted in the SBO's response. I make the point again real fast that such an interlocutory judgment that's acquired, that's gained against one defendant, okay, just legally, all the precedent says you cannot use that judgment as a basis to obtain judgment against other answering defendants. That judgment is actually subject to being defeated by those other answering defendants, okay, which in this case it actually ends up doing, or at least more than a scintilla of evidence is raised to try that issue at this point. Now, don't get me wrong, by the way, this issue that Mr. Chiada brought up about capacity and stuff, because this does appear really as a shareholder derivative case, and whether those are issues that are going to be handled on remand as to whether it's appropriately being brought as a derivative case or such. When counsel said he had not seen the WBL to SBO2, then it's right there, court's record 806. It's part of the motion for reconsideration. And I point out to the court in the last few seconds, the reality is, once again, court's record 736, prior to the court making his ruling, if you would indulge me just one moment, prior to the court making his ruling on the intervention, striking the intervention, in SBO's response, they specifically alerted the court, told the court that to the exact thing, this is at 736, the WBL, the parent company 1 and 2, assigned the note and lien back to World Business Lenders, which was recorded November 18th, in the real property records, giving the document number, and immediately right after giving the next document number, that it went from WBL to SB2. That, when he says that evidence was, since the court didn't pay attention to that, in the reconsideration, we actually put it in front of the judge itself. It's always been in the property records. So, and lastly, Your Honor, the statement about those corporate approvals, those never get filed in the property records. So it doesn't exist. Once again, thank you, Your Honor. It's been a pleasure.
Thank you. Thank you all.